Hello and welcome to this month's edition of Family Law Hour. We are going to dive into a really exciting but maybe complicated part of the divorce and custody process, which is hearings. When the parties don't agree, we're going to talk about how to prepare, what the court is looking for so that you can at least get some initial information about contested hearings. So if you haven't already, or if you've started to try and look for information on the internet, you may have realized it's kind of hard to find, especially when it comes to hearings. There's not a lot of information out there. You're not sure what's accurate or if it's how it works in Colorado. And quite frankly, hearings and presenting a case to a court is what lawyers are trained to do, right? We go to law school to do that. And so it's not information that's typically readily available if you're trying to do a hearing on your own. And so that's what I wanted to go through and talk about today, is just provide that basic information so you knew the foundation to work from, and then certainly you could build from there. So I'm Lauren Lester. I am a family law attorney in Colorado. I help folks break up for the better. And I just don't believe that people should drain their savings or go into massive debt to pay legal fees to break up. And I have certainly seen folks pay $10,000, $20,000 or more, especially if there's a hearing, because both sides have to present their case and the court has to make a decision. And there's a lot that goes into that. So my approach is down to earth. I try and provide reasonable advice if you work with me as a client. And what I'm here to do today is to just provide information so you can make the best decision for yourself and your family. That said, every case is going to be different. Every family is going to need individual attention. Every individual is going to have a unique set of circumstances. So today I'm only providing information, and it's going to be specific to Colorado. And nothing that I say today should be taken as legal advice for your particular situation. If you are looking to get some advice about how things should go in your particular case, or how you should approach something that's happening in your divorce or custody, you want to speak to an attorney. So today I'm just going to go over the basics, just some information about how hearings work, why they happen, what the court is trying to do, what generally has to happen beforehand, how the flow goes, but nothing is going to be particular to any specific case. So if you need that individual advice, do be sure to contact an attorney. So that being said, let's jump in and talk about contested hearings. So a contested hearing occurs when something or many things are not agreeable between the parties. So this is going to be either in a divorce or custody case. So there could be one thing, let's say it's just child support. The parents agree on everything else, but they don't agree on the amount of child support. Or it could be everything. The parents don't agree on anything, whether it's child support or a schedule or how to divide assets. If it's a divorce case, right, they just can't see eye to eye. They can't reach a resolution on anything. So to get these cases done, a decision has to be made one way or another, and that's done through a contested hearing. The judge is going to be the one who makes the decision after they hear the evidence and testimony that's presented. Hearings are similar to trials that you may have seen on TV or maybe been a part of previously, but there is no jury. So in family cases in Colorado, the judge is the decision maker. They hear the facts and they make the decision. And also, unlike TV shows or movies, we also don't have trials by ambush. So there's rarely, if ever, that sort of surprise, I'm going to call this witness and the other party had no idea, right? We just don't work like that in family cases. As you'll see in a little bit, really everything is kind of laid out ahead of time before the trial even starts, from positions to arguments to support to witnesses to evidence. So both parties get a fair shot at preparing. So there's no surprise moment or ambush that happens in these cases, because at the end of the day, especially when we're talking about kids, we don't want surprises, right? We want everything to be fair, and we want the court to make the decision that's in the best interest of the children. So there's no game playing to try and get around that. With hearings, there is a lot going on, both before the hearing and during it. So in addition to the presentation of the cases, there's also procedure that needs to be followed and a whole host of evidence rules that have to be complied with. So this is where having a lawyer either help you prepare or be there with you is really going to be invaluable. And keep in mind that if you don't have representation, the court has to hold you to the same standard as if you did. So that sort of means the court, expects you to follow the rules of evidence. And that can sometimes be hard to do if you don't know what they are. And so the information hopefully you'll get today will give you a sense of what's expected of you. But what I generally find is most folks, once they understand that, do try and get some help because there really is so much going on when it comes to hearings. So if you have the budget, if you have the resources where you can pay for a lawyer, you can just have them help you with the hearing. So if this is something you've gone through the whole case yourself or you have felt comfortable going through the case yourself and you want to save that money in case there is a hearing at the end, that's a really good use of funds and you're going to get a lot of value out of it. Just because you have a lawyer doesn't guarantee an outcome, a certain outcome, and it certainly isn't going to be cheap. There is a lot that goes into hearings, and so most of the funds that are spent in divorce or custody cases tend to clump around hearings. But if you have the resources to do it, it will put you in the best position to make your argument if you have an attorney there with you who can help you organize that argument and follow the rules of procedure and the rules of evidence so that you don't get tripped up on any of those. So before a hearing actually occurs, it tends to be set sometime in the future. In general, about 63 days prior to it, witnesses need to be disclosed. So this means that any person that you may be calling as a potential witness, whether or not you've affirmatively decided that that's going to be the case or not, you do have to disclose the information about those folks, whether they will be a lay witness or an expert witness, and that has to be shared with the other side and vice versa. So again, that gives each party an opportunity to prepare. You kind of get a sense of where the other party might be going based on the witnesses that they list that they may call. Just because somebody lists a witness doesn't mean they're required to call them during the hearing. They do have the option if the witness was disclosed. Alternatively, if a witness was not disclosed properly, sometimes that can be a bar to have that witness testify at all. So you want to be sure to comply with these procedural rules so that, again, you're setting yourself up to make the best argument for yourself and you're not having a witness that you really relied upon not be able to testify because their information wasn't disclosed properly. Usually between 7 and 14 days before the hearing, exhibits are also exchanged. So this is what you will presumably use in your case presentation during testimony, whether it be through you or through a witness, of the actual exhibits that you may offer to the court. Again, just because an exhibit is listed doesn't mean it's absolutely going to be used or proffered to the court, but it does, again, give each side ample opportunity to prepare about what the other side could be presenting. And if they have documented evidence or records that they're going to present to the court, you want to know that. And sometimes that changes your position, quite frankly. And so that has to be, those potential exhibits have to be exchanged, usually 7 to 14 days. And then in addition, usually a week before, if not sooner, the court is also going to require that you provide either a pre-trial statement, and that will happen if both sides are unrepresented, so they don't have attorneys, or a trial management certificate. And if there's at least one attorney on the case, usually the court has a trial management certificate, which is one document that has both sides' positions on it. And the attorney usually takes the lead in kind of putting that together and drafting their client side. And then if you are the unrepresented party, you would fill in your sections. So that needs to be provided usually a week ahead of time. It gives the court a sense of what to expect, where each party is coming from, but it is not evidence. So the pretrial statement or the joint trial management certificate are not considered evidence by the court. They just sort of give the court a sense of what are the issues, where's each party coming from, what witnesses might be called, what evidence might be presented. It gives the court just a little bit of a heads up. You do want to confirm the specific deadlines with the judge or the courtroom that you are actually assigned to for your hearing. Sometimes judges require that the pretrial statement be 14 days in advance, or that exhibits only need to be 7 days before. So you want to make sure that you're complying with those deadlines, because again, if you don't, there is the possibility that something you wanted to present is not going to be presentable because the procedural rules weren't followed. So do double check. The dates that I gave you are sort of in general, but each judge may have, or your judge may have specific rules they want you to follow. So make sure those are the deadlines that you're following. Okay, so let's talk about the hearing itself. The purpose of the hearing is for each side to present their case, their position, what they want, and the support for that. And so your job is to prepare your case in a way that's organized, and that is very specific to what you're asking the court for and why you think that that is the appropriate resolution. The court's job is to apply the facts that it is given through the testimony and evidence by both parties and apply the legal standard to make a determination. So the family courts and the judges and magistrates do have a lot of discretion in general to make decisions, but there are factors or guidelines, depending on what we're talking about, that they need to follow. And so they're aware of those factors and guidelines, and they're going to pull facts for each of those to help make their decision. So if we're talking about finances or splitting the marital estate or calculating maintenance, right, there's a specific set of facts and calculation that the court looks at there. If we're talking about kids in custody, the court's generally going to be looking at the best interest of the child factors, and obviously the child support calculation that the legislator has put together. If you are wondering what exactly goes into those factors and what the court is considering, go back and check out previous family law hours that I have put out, because we just did cover those a couple months ago and go through the factors in each one of those scenarios so that you can have a sense of exactly what the court is looking for. So when we get into the hearing itself, you show up to court, the court will call the case and turn the record on. All of these are obviously recorded so that there is a record of them. To start the case, the court sometimes will go through sort of administrative or procedural things just to make sure everybody's on the same page. And then sometimes they will ask for opening statements, but usually in the interest of time, because these hearings are not set for very long, the court will tend to ask if the parties are okay with the pretrial statement or the joint trial management certificate being considered the opening statement. The court's already reviewed that. So the court kind of gets a sense of where each party is coming from, and it just saves a little bit on time and efficiency. When your hearing is set, depending on how long it is, sometimes they're set for half an hour, 2 hours, half day, full day, multiple days, right? It sort of depends on the number of issues. In general, the time is going to be split equally between the parties, right? That's the most fair way to approach it. But you do want to confirm when the hearing starts if the court is reserving any of the time to make its ruling. So sometimes if it's an 2-hour hearing, the court in its head is thinking, okay, well, I'm keeping half an hour for my ruling. And so that really means that the case presentation is only an hour and a half. And when you split that between the parties, right, so you may be thinking you have an hour, but really you have 45 minutes. So just keep that in mind. Some judges are very strict and sticklers about timing, so you don't want to assume you're going to get extra time. You want to get everything in that you want to say during your time. That way you're, again, not cut off and felt like you didn't get to say everything you wanted to say. So be very mindful of that time frame. The moving party is going to go first during a hearing. So if you have a divorce or custody case, and this is the first time this case has been before the court, that's usually going to be the petitioner. They just go first. If you have a motion that was filed after the fact, it's usually the party who brought the motion. So whoever the moving party is, they're going to go first. And they will call their witnesses and present evidence through those witnesses. Sometimes, a lot of the times, quite frankly, the only witness is the party, which can feel a little bit awkward when you're representing yourself, because you say, Your Honor, I call myself, or I'm going to testify. The court will swear you in, and then you'll go through your testimony. If you don't have an attorney, You will just be able to simply testify and make your statements. If you have an attorney, your attorney is going to ask you questions that will elicit your testimony. So the moving party is going to go first. They're going to call whatever witnesses they are going to call. It's important to keep in mind that witnesses can only testify to things that they have personal knowledge of. So this means they saw it with their own eyes, they were present during something that happened, they know about it from their personal knowledge, right? In most cases, that means that you can't testify about what somebody told you. So as soon as somebody starts saying, oh, well, on June 2nd, his mom told me that he didn't want to have the kids. As soon as you say his mom told me, most likely you will get an objection if there's somebody on the other side, if there's an attorney on the other side. And for the most part, the court can't consider what his mom told you because his mom isn't there to testify, right? So you can only talk about things that you have seen directly, that you know directly, and aren't through somebody else or what they told you. There are a ton of exceptions to that sort of don't talk about what someone else said. And that's, again, really where having a lawyer's help, at least even in preparing for the hearing, even if you can't afford having them come to the hearing with you, even having them help you prepare is going to be invaluable, because you can say, well, I want to talk about how his mom said this thing. And the lawyer can walk you through and say, well, based on what you're telling me, I don't think that that's actually admissible evidence, or that testimony is going to be objected to. Or they may say, you know what, that falls under this exception, and make sure that you follow this procedure so that the court can see it follows under that exception. So again, that's where having an attorney's help is going to be super valuable, because we're trained to know and we have the knowledge about those evidence rules. If you have actual evidence or documents or reports or pictures or text messages that you want to present, those are presented through a witness. So again, the witness has to have firsthand knowledge of the evidence itself and testify that the evidence is what they say it is. And once again, there's a ton of rules when it comes to the actual evidence that's presented. So if you have something that you want to show the court, a text message or an email or talking parents record or this photo, anything, if you can get a lawyer to help you prepare so that you understand, one, if it is admissible, two, the testimony that has to happen before so that the foundation is laid, and then three, if there's going to be any objections or how to sort of procedurally get it before the court so that the court can actually admit the document or evidence into evidence in the court's record and consider it as part of their decision making. So witness testimony and evidence, the purpose of presenting it to the court is to support your position. So if your position is, I think that the parenting time schedule should be a 5-2-2-5 schedule, you want to present testimony and evidence that supports that. And the other party may say, well, I think the schedule should be every other weekend, whatever it is. The purpose of the witness testimony and evidence is to support that position. So it's slowly building bricks, right? There's usually never anything one witness says or one piece of evidence that is a slam dunk in a case, right? These are moving cases. They're very gray. We're talking about families and children here, right? It's never black and white. And so the more small bricks that you can lay through your testimony and your witness testimony and the evidence, that's going to support your position. Once a witness is called by one party, so whether it's you testifying or maybe you've called someone else as part of your case presentation, the other party is then allowed to ask them questions, which is called cross-examination. Again, there are some fantastic movie scenes that happen with cross-examination, right? It gets very heated, it's very dramatic, but that's usually not what actually happens in real life. It tends to be a bit more boring than that. But the purpose of cross-examination is to highlight holes, maybe in the witness's testimony. People tend to talk about the facts that are most positive for them, right? And they tend to skim over the stuff that's not and maybe as positive. So you may poke holes to try and illuminate those not so positive facts. Inconsistencies, so if the witness testified to things differently, or maybe they testified to one number about the value of the home, but in a document they filed with the court, they said it was another number, right? Inconsistencies that are occurring, or just maybe that the witness wasn't truthful. Maybe they said, oh, I never sent a text message that made that threat, or, never sent a text message that said I wasn't agreeable to week on, week off parenting time. And then, you have a text message from them that shows that they did say it, right? So they weren't being truthful in their testimony. So that's the purpose of cross-examination. The scope is only about what was discussed on direct. So if they don't talk about something on direct, like, the repairs that need to be done to the marital home or something, and that's a big sticking point to you, like they just don't even address that topic, generally on cross-examination, you can't bring that up. It's just limited to what was discussed on direct. And then after the cross-examination is finished, the witness can do what is called redirect. So if there's an attorney, they can ask them some clarifying questions in case anything came up on cross-examination that they want to clarify. Or if you're representing yourself and you're the one testifying, you can provide clarity just on what was talked about on cross. Again, you can't go, oh, I forgot to talk about this other thing before, so can I do that now? It's not the time. That's why you really want to be organized for your testimony and plan it out ahead of time so that you cover everything you want to, because if you forget to do something and it wasn't talked about on cross-examination, you can't then bring it up. So after the moving party calls all of their witnesses, they've presented their case, they've presented all of their evidence, the same flow is going to happen for the other side. So then the other side's going to get up, they're going to call their witnesses. It may be just them. They may have other people that they call. They're going to present evidence through the testimony. Each witness is going to be able to be cross-examined. Each witness can then have the opportunity to offer redirect. And then both sides sort of rest. They've presented their cases. They presented all of the support that they want to show the court that the court should make a decision in their favor. And then the court will decide. You may find in your hearing that sometimes the court asks questions all during the hearing as the evidence is being presented. So sometimes the court will interject and ask a question of a witness, or ask you a question if you're the one testifying, because the court is trying to gather information that it needs to make a decision. So if that happens, it's nothing to be worried about, but you do want to answer the court's questions truthfully. So once both parties have presented their case, sometimes the court will ask for closing arguments. This is something you'll want to have prepared ahead of time, because you don't want to get caught in the position where the court asks for it and you're like, oh, I don't know what to say. I don't have anything prepared, right? You want to have it prepared. If the court doesn't want to do closing arguments, that's part of its discretion. Then you just don't use that piece of paper. But if they do, you want to have it ready. It's really important to remember that closing arguments are not testimony. It's an argument, right? It's a chance to take and summarize the evidence that you presented and the testimony that you presented and just wrap that into your position. To say, I really think that the marital home should be split 60-40 because bop, 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 right? And all of those things are evidence or testimony that were presented during your hearing. So you can't come up with anything new. You can't, again, say, oh, I forgot to talk about that one thing. Let me throw it into closing arguments. The court is just not going to consider it because it's just not part of the procedure. And it wouldn't be fair, right? Because the other party doesn't have the opportunity to respond. It's really important from closing arguments to the evidence and testimony presented, even back to the pretrial statements, to focus on the legal standard, because that's what the court is using. So if you're talking about a custody schedule, you want to have the best interests of the child factors available, and you want to craft your evidence and testimony around those. So the first one is, the wishes of the parent. So part of the testimony should be what you wish for, as a parent in your testimony. The location of the parents to each other. So you want to make sure in your testimony it's discussed, well, I live 50 miles away from the other party. You have to get all of that information in, because that's what the court is using to make a decision. And once all of that has been presented, the court's going to make its ruling. Sometimes the court will do this right then and there at the end of the hearing. Sometimes the court will take the case under advisement, which means that they have taken notes, they've heard everything, and they're going to think about it and craft a written order sometime in the future. Usually it's a week, 2 weeks, can be up to a month, depending on sort of how much was covered and what the complexities are. But the court isn't going to give you an answer right then and there. They'll issue a written order. Either way, whether the court gives you a ruling right then and there and says, okay, I've heard the testimony and evidence presented, and, here are my findings and here's my ruling. That's the end of the hearing. That's the end of the presentation of evidence. So it is not the time to argue with the court. The court's ruling is what it is. It used the evidence that was presented and it made a determination. So that's the risk in going to a hearing, is the outcome is out of your control. You can present the best case ever and all the support. And if the court doesn't agree with your position or thinks that, the truth is somewhere in the middle between what you and the other party presented, or agrees with the other party's assessment of what's in the kid's best interest, that is what it is. And so when the court gives its ruling, you just want to listen, take any notes that are necessary so that you know what the ruling is and what the rules are going forward. But that would be the end of the hearing. So where do people get tripped up the most when they do hearings on their own? You can do it on your own in Colorado. There's no requirement that you have an attorney. As we've talked about and I've said a bunch of times, it's tremendously valuable to have an attorney with you to make sure that you present your argument in an organized fashion, to make sure that you hit the factors, to make sure that you aren't talking about anything that's irrelevant, and that objections are being made when they should be made, and evidence isn't getting in that's not appropriate, right? All of those things are what we as attorneys are trained in doing, part of what we're trained in doing. So even having them help you prepare is going to put you in a much better position. But even folks who come on their own and present their own case sometimes get tripped up. So here's a few pitfalls to try and avoid. The first one is, and this happens a lot because folks haven't looked at the statute or haven't read through those factors and aren't keeping their argument focused, is that they talk about something that's irrelevant. So for example, Colorado is a no-fault state when it comes to divorce. So that means if you're getting divorced because he's a jerk or she cheated on you or he ran off and you haven't seen him for 10 years, it doesn't matter here. In general, there are a couple of exceptions, but in general, it's a no-fault state. So when people are going through, why they think the bank account should be divided in a certain way, they'll start talking about, well, I think I should get more out of the bank account because, he was a jerk and he sent me these nasty text messages and I could never get a hold of him. And, he was doing all of this stuff and that's why our marriage ended. They spend, 20 minutes of their time on that, kind of airing out their grievances. And I understand that it can be very cathartic, but the problem is the court is looking at its factors on, okay, well, how do I fairly divide this bank account between these parties? And none of those factors say, was the other party a jerk? And so now you've wasted the court's time and haven't given them anything that can help them make a decision in your favor or sort of close to what you were thinking about. So it's really important to follow the legal standard. And as much as you might want to bring some other stuff up, if it's not relevant to those factors, don't bring it up. You'll just waste your time, which is going to be very valuable and limited during hearings. And you might distract the court, right? The court doesn't want to get involved in the mudslinging. And sometimes that can really irritate the judge, especially if it goes from both parties and it's not relevant and the court just wants to be able to make this decision and let these parties move on. So you just don't want to get in that position where your argument is clear, but now it's been all muddled because of all this other stuff has come up. The second thing that folks do is they don't follow the procedure. This can sometimes be hard because, right, you can't Google what's the procedure in Colorado for a hearing. So if you're just sort of coming in on your own without any preparation, what I see a lot of folks do, if both parties don't have a lawyer, is the first party will testify, right? They'll go through their spiel and give their a testimony and evidence. And then the other party will get up to do cross-examination, right? Because the court will say, okay, other party, do you have any questions for the first party? And the second party will just start testifying. They'll just say, well, I didn't do that. I didn't say that thing that you said. And I think the kids, need to be in this schedule. And that bank account, I'm the one who contributed to it, right? So they'll just start testifying. They're not asking any questions on cross-examination. And so because they're not following the procedure, the court's going to interrupt and say that, this is not the appropriate time to do that. And sometimes when that happens, you get flustered because you weren't expecting it, or you feel like the court's not listening, but they will listen to you, just not right at that moment. So it's really important to follow the procedure and ask questions on cross-examination, and know that if you're the second party to go, you will have an opportunity to testify. You will have an opportunity to say from your point of view all the things you believe are not correct in what the other party said, but you have to do that at the right time. The third thing that folks fall into a lot is they want to call character witnesses. So let's say we have a custody case and the two parents disagree on what the schedule should be. I've had, clients who I've worked with or parties who I've helped them prepare for a hearing come and say, well, I want to call my mom and my sister and my cousin and my best friend to talk about, how I'm just such a great mom and I love my kids. And every time that they're with me, they love it. And we have so much fun together. And the other party, when he comes for pickup, is really aloof and doesn't engage with the kids. That's fantastic. You are definitely a great parent. And I'm sure all those people would say the most wonderful things about you. The problem is, one, the court expects your mom and sister and best friend to say great things about you. So it's not super helpful, to be honest, to the court. The court's going to assume both parents are good parents, or at least decent parents. So it's not helpful to the court. And bolstering with character evidence, again, is not one of the factors. One of the factors is not how many witnesses did this person bring to say that they're a great person, or they were an excellent spouse, or they're a fantastic parent. It's not one of the factors. So if one of those witnesses can talk about from their own personal knowledge and first-person perspective about what the other party does at exchanges with the kids, sure. But if that's also something you see because you were there too, that additional witness isn't helping. They're not adding anything additional. You're just trying to make your argument stronger because you have 5 people saying the same thing, and that's just not quite how it works. So calling character witnesses, or calling people to just back up what you're going to say, or even witnesses that are going to speak ill of the other party's character, most of the time is probably not helpful. It feels like it should be, right? Because in the court of public opinion, it generally is. But in the court of law, when we're talking about a family case, what the other party, whether or not they're a jerk to you or said mean things to you or are, dismissive to your parents when they see them, not going to be probably too relevant. So be organized in your testimony and your approach and your case presentation. Have evidence that's going to be really strong and support your case, and follow the procedure. Those are the best things that you can do to set yourself up to make the best argument. Again, no guarantees. There's absolutely no crystal ball or affirmative stamp that the court is going to agree with your position. But you do want to put yourself in the position to make the best argument and not be distracting to the court, not talk about irrelevant things, not, waste the court's time. Those are all things to try and avoid. So once again, while you can represent yourself at a hearing for a divorce or custody case or anything along those lines in Colorado, as you can probably see, there's a lot going on, right? And every case is going to be different, and it's going to depend on the witnesses and the facts and the particular judge that you have. So at a minimum, most people will have questions. Many people at this point in the process do try and get representation because there is just so much to manage and know to make sure that you make the best case presentation for yourself. So consider that. If you are looking for more cost-effective solutions, or at least help from an attorney that can give you a flat fee upfront, that is how I work. So I will give you a quoted cost for what it would cost for me both to just help you prepare for the hearing so you can be in the best position to present it yourself, or to have me go with you to a hearing. You will get an upfront cost based on the facts of your case and the situation that you're in and the issues that need to be addressed, so that you know what that cost is going to be. I don't work where you write or you provide a retainer and that gets billed against and you're never quite sure where the end is, or what the final cost is going to be. I do offer that flat fee up front. So if that's helpful, if that makes it more economical, if you can budget for that, do check out my website, mylifelawyer.com. It's also down below in the notes, and see what the price may be, and you can schedule your free consultation from there. So if you can get any help, again, even if it's just to help you prepare, but you go to court yourself, it's going to put you in a much better position than if you just walk in and start talking. So I hope that this was helpful today, talking about contested hearings in divorce and custody cases. I will be back next month, as I am every month, on the second Wednesday at 12 p.m. So do make sure that you subscribe so you get alerts. And you can also, if you have any questions, provide them below in the comments. And I'm happy to provide any additional information that may help you. Again, I can't provide any legal advice, but if you would like to schedule a free consultation, be sure to do that on the website, mylifelawyer.com. Thank you so much for watching, and I will see you soon. Bye-bye.